Looking at the table in front of me, I see a group of true believers who have faith in the process. Forgive us if we don't share it. The notion of the precautionary principle is understood by most people of ordinary common sense, with it assert that if a project in an area such as ours contains significant but essentially unquantifiable risks, it ought not to proceed. But as defined in the Planning Act, apparently it's interpreted as just us applying the fullest extent of our technology and knowledge at a given time in the fond hope that it'll all work out in the end. And if anything does go wrong, all the proponents and all those involved can just shrug their shoulders and say we did our best. That won't be good enough in this case. And the managing business goes out of business because of economic downturns or, as Mr Fletcher might suggest, repeated council lawsuits. Who's left holding the eco-catastrophe baby in this case? Will it be the ratepayers of Shoalhaven, the taxpayers of New South Wales, or the owners of the property over which the lease is held, the Vincentia Corporation?
If I understand the question correctly, and help me if I don't get it right, you're asking in simple terms, what happens if everything goes wrong, goes built out? At the end of the day, as I've explained previously, Council, through the consent conditions, if we assume that it's going to be approved, imposed and agreed to by the Joint Regional Planning Panel, will have to administer that consent. That consent should contain conditions which require regular environmental monitoring. It's not just Council. DECC also issue licences, and other state agencies have individual licence arrangements for particular aspects of the operation. So there are several arms of government that are involved. At the end of the day, if they don't comply, if it goes out of business, then obviously a level of impact that's associated with its operation would cease. Some people would probably be quite happy with that. There is an issue though in terms of if I suppose a scour or a extraction site which is unacceptable in terms of its visual appearance, its potential sedimentation or erosion, its leachate runoff exists, then Council does have opportunities through protection of environment legislation to impose orders and take actions, if necessary, court action, to address those impacts that are occurring because of the lack of operation of the development.
Against whom?
Sorry?
Against whom?
Sorry, one at a time please. I'm happy to answer as many questions as you ask, but against who was the question put by Chris? We obviously would take an action against the owner of the land, the person that enjoys, or the company first, the owner next, in terms of we can take a number of actions, the person that enjoys the benefit of the approval, the person that is responsible for the lack of commitment in terms of restoring the site, or indeed not complying with conditions, or whatever the case may be. Yes, it could be messy, yes, it could take a long time, yes, there are potential problems. We hope we never get to that situation if it is approved.
So can I just clarify this? I'm not wishing to ask another question. This is just a clarification of that. So what you're saying is that if the managing entity goes out of business and evaporates, at the end of the day, Vincentia, as the landowners, could be carrying the baby.
Yeah, look, this is a fairly complicated legal question. Obviously, we would seek to take action against the operator and the person that enjoyed the benefit of the consent. The extent to which we can sheet that responsibility back to the landowner really goes to the fact that it may result in an unacceptable operation that exists on their land, and as a landowner you have an overriding responsibility to ensure that an activity undertaken on your land does not lead to an adverse environmental impact.
Thank you.
But it is... do you want to Robin might elaborate on that?
I hope you can all hear me. This is a fairly controversial sort of application and proposal, and equivalent to this sort of exercise or project is what happens in the coal industry, where the coal authorities that govern and regulate the coal industry, particularly in terms of rehabilitation, take substantial bond securities in terms of cash deposits or bank guarantees to ensure that at any time during the process there has to be rehabilitation. For whatever reason, there are sufficient funds to rehabilitate the quarry or mine at that point in time. So the government hold substantial monies from coal companies for that very purpose. And I guess whilst this is perhaps nowhere near the same scale of operation as a coal mine, it nevertheless is a very important operation if in fact it came abruptly to an end, that there would be sufficient security held to effect reasonable rehabilitation of the site, so it's not left as an open landfill.
Page 121 of Watkinson's Applebee's Proprietary Limited's EIS, there is a table that states 250 kilograms of each tonne of contaminated waste can be asbestos. What does Council see as an acceptable amount of asbestos, and what will Council do to make sure this is monitored? Bearing in mind that Huskisson Tip was closed for several months in 2005 because of asbestos.
That is a good question. In terms of the list of items that have gone on that non-putrescible list, which is defined by DEC in terms of waste stream, in the processing of this application, what the panel has to decide is whether it's going to allow all those particular waste streams that are identified on that chart to be received at this tip, or this landfill. And I think in an area where there is a fairly narrow buffer between the quarry and the encroaching urban areas, and more importantly the water bodies leading to two significant waterways, being the bay and the basin, then perhaps a more restrictive approach to the types of waste that comes into this landfill needs to be employed. Particular care needs to be taken in dealing with it. I guess there's been a lot of talk about, is this the best site? Would there be better sites elsewhere located around the city?
Newcastle, perhaps.
Your place. Your backyard.
Yes, money will be there. Yeah. I'm not talking in favour of this project, I'm just advising you as to what measures could be employed by the panel and what considerations could go into our 79C assessment report in terms of whether or not that full gambit of putrescible waste items should be suitable for this tip. Now, that's a decision that has to be made, and when there is not the sort of distance buffering between the very sensitive areas of residential, rural residential water bodies, then perhaps you have to be more selective on what you allow to go into the landfill.
You said putrescible.
The applicant wants to respond to that as well.
The question was in regard to asbestos waste going into the site, I believe, and the reference to asbestos inside the EIS. The asbestos is not inside the groupings of non-putrescible waste that were read out to you earlier on. It will be prohibited from the site. It's actively banned from the site. With regard to the reference to it in the EIS, that's work I did in regard to the greenhouse gas generation. I had to log onto some form of waste stream to do modelling. The only credible information that was available from the EPA was on DNC waste streams in Sydney, which is quite clearly defined inside the tables. That was done to model the greenhouse gas generation of the proposal, nothing else. As far as this proposal is concerned, in terms of what it will be allowed to receive waste, it will not be allowed to receive asbestos.
Can I just clarify?
Inside the category of non-putrescible wastes, it's not allowed, and it won't be brought into the site.
They sneak it in.
The percentage that I used in terms of my greenhouse gas modelling was based on DNC waste streams in Sydney. To do this modelling, it was a complex exercise to do because there's not much modelling on this type of waste.